so much for tuning into our webinar series on estate planning for families. Stay tuned, there's going to be so many different kinds of videos and webinars that we're going to be doing, some for moms, some for professional women generally, what everybody should know, special needs families, the families who have children living with unique medical and financial needs, all kinds of things. So if you know someone who is in one of those communities, if you are yourself, stay tuned so you can listen to all the really awesome information and nuggets and how this pertains to you and how Lilac City Lock can help. Thanks again. Thank you again for joining us. Stay tuned to the end and we'll talk about not only the solutions for how this may affect you and your family, specifically your children, but also how we can hopefully help address those issues and solve some problems ahead of time. It's all about prevention and planning, which will keep our families and loved ones out of court and chaos and conflict should anything happen to us. Help if I can get to the next slide. I appear to be stuck here. Oh, there we are. Sorry, guys. Okay. So kids protection planning, estate planning generally, but especially when we have little ones at home, it's planning for a lifetime of protection, guidance, and love. So, you know, for a long time, a little over 10 years now, I've been an attorney and I've been helping disabled children, workers, and veterans fight for and get their federal disability benefits. That's been really amazing work. I now have 2 little girls. They're 5 and 2. And when my husband and I were away on a trip, 3,500 miles away, it was brought to our attention that we had not done our own estate planning at all. There were no legal documents in place to take care of them and everything else we've worked so hard for if we didn't come home or if something were to happen to us and we were incapacitated for a time. And I'm a lawyer. I read laws, I do this stuff for a living, but you know, you don't know what you don't know, and it's really hard to get your heart to wrap its little mind around this concept of not being there for your children. I look at my little girls and I think I have to be Wonder Woman. I have to be invincible because they need me. I need to be there. I want to be there to watch them do all these amazing things, and they need us. So, you know, it's something that you sort of think about in passing. I need a will. I need to make sure that the right people would raise them if we can't. But it's the kind of thing it's not the fire that's burning, so you just kind of stick it on the back and you say, well, I'll get around to it. I'm in good health, I'm young, I'll get there when I get there. But you know what? I'm here to give you that little bit of push, and in a not alarmist way. I'm not here to infuse a fear factor in you other than to share with you a sense of urgency about why every family needs an estate plan and a kids protection plan. So the question that I like to start off with, I think for me is kind of the scariest question, so I'll start with that, which kind of just sets the stage. What happens to your children if you don't come home? So husband and I are on a date. We're supposed to be home at 10. Sitter's calling at 10:30. She trusts us. She knows that, you know, we're generally on time. We always call ahead if we're running late. We're not available. Nobody's picking up their phone. It's 11 o'clock. It's 11:30. She's really starting to worry. What happens? And I'm just going to kind of let you sit in that question for just a few seconds. But don't worry, we will answer that question. Because there is an answer. There's a short-term answer. So the short-term is sitter would likely call law enforcement, so 911, who would come over, or alternatively, if you're, God forbid, in a car accident and first responders have already come to the scene. They've probably gone through your wallet to find your identification, learn of your home address, and then they show up at the address to see if there are any children. My car has 2 car seats in the back, so that would certainly tip them off. Then they show up at the door, they see the sitter. They're going to wonder, does she have legal custody? Is she a guardian? If not, they're going to call in social services to make a determination as to who an appropriate temporary guardian should be. It's not going to be the sitter, so she's going to be dismissed. So if it's 1 o'clock on a Saturday morning and the kiddos are sleeping, and now the children need to be packed up and brought to crisis nursery or other social services, DSHS if you're in the state of Washington, that needs to happen because the state needs to assume at least temporary custody until they can find a fitting guardian, hopefully closest of kin. But who are those people? Is it someone that you would prefer? Is it someone who's farther away? Is there someone better suited for that job during that period of time? Also, you want to consider what's going through the minds of small children at that moment, with a police officer at the door, 1 o'clock in the morning, going with them with none of their familiar stuff or any familiar faces. Long term, also a plan. May not be one that you love. Ultimately, if you don't have a plan in place and you don't have nominated guardians that you know, love, and trust, whom your children know, love, and trust, it's going to be up to a judge to make that determination. If you have a family with lots of loving family members, all of whom feel they would be best suited to care for your child or in the long term raise your child, that has the potential for causing a lot of conflict in your family. If you are in a partnered family or you're married, then you have 2 sets of families who all really want the best for your children and want to do what you would want for them. But that's a lot of interpersonal communications to sort out. Lots of different personalities. Everybody's stressed out. To the extent that you're no longer there, they are also dealing with their own personal grief, and on top of that, your children are too. I promise, the end, this does turn around. It's not like the saddest story ever, but it is important. It's reality. It's things that we as parents need to come to terms with, and we can take care of that. So something also to consider is if it's just me who has passed away or I am incapacitated such that I cannot communicate, will my spouse respect my wishes? So if I've passed, so there's a case where the mother passed away, dad stopped letting maternal grandparents visit with the children. Grandparents started fighting in court. This went on for years and years. It was very costly, likely traumatic to the children who now didn't have a living mother and couldn't see their maternal grandparents, but we don't know what the relationship was like, right? So ultimately what ended up happening was the court did award visitation rights to the grandparents. However, dad's position was that when mom was living, that they had agreed between them that if something were to ever happen to mom, it was his responsibility to keep those children from her parents. But nothing was ever written. So how do we know? Do we know? Was he respecting her wishes, or was he going outside of those wishes? We'll never know, because there was nothing written. And that's really the essence of why every family needs an estate plan. And we'll see more about that here pretty soon. So in our office, we do a kids protection plan, and it's its own sort of separate set of documents that I think really round out what parents of young children need for both death and incapacity planning. So in a will, of course, we want to name guardians. So these are long-term guardians in the event of your death. That's why you have a will. But I think what's needed is you go a step further. You also name them outside of the will, because that will, as I said, is only a life document if you passed away. So if you are incapacitated for a period of time, perhaps you're in rehabilitation for a number of weeks or several months, you're in nursing care, so you're not in a position to sort of like physically parent. Someone has to actually care for your children and your stuff, your life, while you're taking up the job of getting better to return to your life. So in that case, your will would not be a live document. So the Kids Protection Plan that we offer has temporary guardians who are going to live in your neighborhood, in your area, so that children are not disrupted from their daily routine as best as possible. They can still go to the same school or the same summer camps, or those things aren't disrupted. They're not having necessarily to move to another state while you're getting better in nursing care. So we talk about temporary guardians, permanent guardians, but also naming them outside the will as well. You see in front of you this family emergency ID card. Those are in the wallets of every one of our families, as well as our own. My husband and I each have our own. And we slide them behind our driver's license. So in the situation where I'm in a car accident and I'm unable to communicate, first responders are going to come and obviously going to open up my wallet to try to find my identification. This is going to slide out behind it and alert first responders that there are children, there are minor children, and these are people who have authority and instructions regarding the care of my children. They're to be called in that order, and those are the people who are local, who can come and protect my children while first responders are taking care of me. So there's no gap. The children don't have to go with people they don't know. They don't have to go into social service care, nothing like that. They're only going to stay with people who we know, love, and trust. Okay, so the meat of our presentation today is in talking about how in the heck do you choose the right people. So for those of you who have written a will perhaps in the past, good job. Hopefully it hasn't been too long since you've last updated it or even taken a look at it. It should not be collecting dust. But especially whether you've done a DIY yourself or you went to an attorney, these common mistakes are common, and not for any malicious reason, just that a lot of estate planning firms and a lot of those sort of do-it-yourself documents are taking the primary position of where's your money and how do you want your money and your assets distributed. A personal family lawyer like us, our firm's going to take a parent's perspective first. What do you want for your children? How do you want them cared for? We can adapt or sculpt the rest of your plan to that end. It's most important for me as a mom that my children are taken care of and handled, if you will, first and foremost, and then whatever happens to the rest happens to the rest. Of course, we're going to take good care of that stuff, but in my mind, it starts with our children. So how do we choose the right people to take care of our children? Well, we avoid these mistakes as best as possible. So mistake number one is naming a couple to act as guardians. I just happen to use my family as examples all the time because it's closest to me. So if we chose, say, my sister and her fiance, they're going to get married early part of next year. But let's say we named the two of them. So Sally and Joe, right? What happens if Sally is in the car with my husband and I, and we've all perished, or now she's incapacitated, so she couldn't parent my children, and we've passed away. So who's left? If we have named Sally and Joe, so my brother-in-law, are we okay with all of that's happened? We're all passed away, and my two children are raised by my brother-in-law. And your answer might be yes. there's no right or wrong answer. It's just what's right for you. But in my case, in my family, that would not be our first choice. We would prefer that it then lapse and go to the next one. But if you've named a couple without any sort of additional descriptor or a condition or things for the reader to be cognizant of in terms of your intention, they have to just sort of strictly interpret it based on what it says. So they're just going to assume you meant to say what you said. So we try to be as descriptive and specific as possible. Mistake number 2. What if something happens to your first choice? So going back to mistake number 1 and kind of drawing from it, if Aunt Sally has passed away with us in the car, and it is not our desire for our brother-in-law Joe to then raise our small girls, then we need to offer a second layer or a third layer or a fourth layer to make sure that regardless of what happens to all of these people, the children are still with someone we are choosing. And a common sort of objection or apprehension that I hear sometimes from families when they're in my office for their consult is, I don't know a fourth layer of someone who I feel worthy to raise my children. Please know that I hear that. I get it. I totally get it. Let me tell you something that I always say to these families. Your fourth choice is going to be so much more appropriately decided, intimately decided than a court. At the end of the day, you know these people better than a court does. So your fourth choice is better than their fourth choice. And if that fourth choice has to be made, yes, so be it. But you've put a lot of thought and energy and love into that decision. And you know your children best at the end of the day. Mistake 3, considering financial resources. So my sister and her soon-to-be husband are young. They're much younger than I am. They don't have children yet. They're just a couple of years outside school. They're just starting their careers. They're not making a whole lot of money right now. So if all of a sudden they went from a young startup family of 2 to a grieving family of 4, that's a huge financial burden. So, something that people tend to shy away from saying, well, I couldn't do that to them because that would bankrupt them. That's a huge burden. My position is the people that you choose to raise your children, you need to make that decision based on how closely those folks would mirror your parenting decisions, your discipline decisions, your spiritual decisions, your emotional decisions, all of those kinds of decisions, not necessarily the financial resources. So it's our job as moms and dads to pay for the raising of our children, quite frankly, whether during our lifetime, but also upon our death. So how do we do that? Well, when I'm alive, it's by working and earning an income. If I've passed away, it's by life insurance. Small caveat, I don't sell life insurance. That's not my thing. But as a counselor in all of this, there are financial vehicles that you can put into place in an affordable way that would help your Aunt Sally and Uncle Joe in your family to raise your children in a manner in which you're accustomed to, or your children are accustomed to, and you don't necessarily want them to miss out on any opportunities that you right now are working towards. So it's our responsibility as parents to put those things in place as well. Something that is sort of part of this topic and this mistake here is you don't necessarily have to agree with, per se, how the Aunt Sally and Uncle Joe spend their own money. it's wise in a lot of cases and a lot of families to make the financial decision maker different, separate from the person who's raising your children. So choose another aunt and uncle to take care of the money, make sure they're invested wisely, and then you have the Aunt Sally and Uncle Joe who are raising the children. And now you have 4 adults, a village, helping to raise your children, making emotional decisions, parenting decisions, and then the financial decisions. So you have you've got people at the table who are exercising their strengths. Okay, so number 4, the court distributes your money. So many of you may or may not be aware of how this whole process works. So particularly if you don't have a will, the court basically has to sort of make all the decisions yourself. They have to distribute all the assets. They have to figure out where your debts are, who should get what's left, who should help be in charge of all that, your personal representative, all of these things. Is that person qualified to serve as a personal representative? Do they need to have a background check? Do they need to post a bond? All of these things will be overseen by the court. And then reference any residual monies or assets. They're going to be distributed if you have minor age children with a financial guardian who may not be of your choosing, someone you would have chosen had you had the opportunity to. And upon their 18th birthday, and we'll get into this a little bit more at the next slide, it's just going to be distributed outright without any protections, whereas it could have been put into a protected trust or some other vehicle. As a side note, and something that's more to the point in another of our webinar series, but if you have a child with special needs, medical special needs, you want to be very aware of how that money might be distributed to your child, because you would not necessarily want to disqualify them for any government services like Social Security, that if they received, the $250,000 proceeds of your life insurance, that would potentially disqualify them for other services. Okay, so mistake number 5, someone challenging your guardian decisions. So as important as it is for us as moms and dads to nominate guardians, to be the right people to raise our children in the way that we want, it is equally important to list folks who should never be around your children, should not have any of those kinds of decision making, be it emotional or parent decision making, be it financial decision making on behalf of your children. If I am saying these words to you and you immediately came up with a person's name, that's the person who should be listed specifically as excluded from the privilege of raising your child. Number 6, not making short-term arrangements. So again, this kind of goes back to that first example about being out on a date and not coming home. If I wanted my father to be the long-term guardian and ultimately raise our children, well, he lives in Florida. We're in Washington State. That's going to take a while. First of all, someone's got to track him down. Then he's got to figure out travel arrangements, put his life on hold, go get over here. That could possibly happen in a day. Who knows? But at any rate, someone has to be taking care of your children. Someone's got to be responsible for them until such time that long-term guardian comes to retrieve them. Who is that going to be? Is it going to be someone that your children know, love, and trust? Is it a neighbor? Is it a trusted friend? Is it a close family member, but not necessarily someone you would choose to raise your children? It could be any of those things, but if you have not made short-term arrangements for your children, guess what happens? Those social services from the state come in and they have the privilege of caring for your children until that long-term guardian from Florida or wherever, another country perhaps for you, comes in to pick up your children. So back to the court proceeding. So probate is a lawsuit you file against yourself with your own money for the benefit of your creditors. Essentially what happens is, if you have a piece of property or you have some other asset that if you were alive and you sold or gifted or whatever, transferred, you would have to sign off on that. But since you have passed away, the court in essence has to kind of serve as your signature, if you will, to oversee that distribution. And so creating a will and having those estate planning documents essentially provides a set of instructions and shows your intent as to how you would see fit for all of the things you've worked so hard for to be distributed, rather than it defaulting to the rules of the state that you live in, or up to your family members who want the best for you but don't necessarily know what your intent would be. So you're putting your own desires, your choices, your nominations in writing on paper. So the way that I like to analogize estate planning is basically, you've worked so hard to create all these treasures. You have your income, your life insurance, your assets, the blood, sweat, and tears that you put into all of this. Without a will and without these documents, you have left no map. So your loved ones don't necessarily know where those things are, how much they're worth, where they should go, how they should be taken care of. As well, probate is completely open to the public. It's voluntary. It's subject to predators. So back to that conversation around the court distributing your money. At age 18, whatever is left of the assets and the monies in your estate will be distributed outright to your children without any protections. And sad as it is to say, there are predators out there who will love to learn that your 18-year-old has just received that giant oversized check for $250,000 that they're going to happily walk over to the bank to deposit into their checking account, and boy, have they got a snake oil to sell for $250,000. So that's a scary thing to think about. The other thing that I think about is if I've not put any protections around the $250,000, for instance, and my child gets it at 18, you have to really wonder how that would shape your decision making. How would that have shaped your decision making at age 18? If I were 18 and received $500,000, $250,000, or $1 million, or $2 million, would I still have made the same decisions to go immediately to college, or just make all those learning decisions, living decisions, life decisions that I did when I was 18? Maybe I would, but I probably would not have. And so if there are certain things and values that are really important to your family, like higher education or starting your own business or anything like that, you can write in protections and conditions to help parent your children, even if you're not there physically. So in our office, our consults are called a family wealth planning session, and to help you prepare for that, we provide you some paperwork. It's called an inventory and assessment, and it basically allows you to get on paper and see it in front of you in black and white. What is important to your family? What are your values? What is important for you to pass on to your children and to other loved ones if you couldn't be there? You'll gather paperwork relative to your assets, your retirement accounts, your brokerage accounts, your real estate, all of that stuff, just your time to really look at it. And then you sit down with me at a family wealth planning session, and we set aside some time to go over this stuff together. And I'll kind of illuminate on the subject as to, based on your current plan, if you have one, or not, what the state would have for you, or for your family, that is, if something were to happen, be it your incapacity or upon your death. And then you can make an empowered, informed decision about whether that's appropriate for your family. Does it address your needs, your health needs, your medical needs, your legal needs upon your incapacity? Does it address your family's needs upon your death? So I want to thank you for listening to this Kids Protection Plan presentation. I know it was a lot of information. It maybe feels like you just drank from the fire hose. I know, especially if this is the first time that you're hearing all of this stuff, you might be feeling super overwhelmed. This book is so awesome. Called Wear Clean Underwear. If you remember the Choose Your Own Adventure books, this is as lighthearted as you can get, a way to kind of walk through a few different scenarios so that you can, again, make an informed decision as to what kind of incapacity or death planning you want to do. We as moms especially spent 9 months making a birth plan. How did we want to give birth? Where did we want to give birth? Was it in a hospital? Was it at home? Was it at a mountaintop with a deer? Whatever was right for your family. You spend approximately 9 months making that plan. And then we don't make any other plans. It's time to do this kind of planning too, as uncomfortable as the conversation might be. I will help you in a gentle way, if you will allow me the opportunity to walk through these different scenarios so that you can make the best choices for your family. But I want to offer you this book. I do it it's a digital format, and I do it in I chunk it up so you don't have to read. It's only 150 pages, but I kind of chunk it up by chapters with a little bit of commentary for me before and after each chapter. It's very easy to read. And as I said, it just kind of goes through some of the different scenarios with a plan, without a plan, with a half a plan, with an incomplete plan, just different kinds of things so you can just see how that plays out. So we offer it digitally on the PDF as I walk through it, and also if Kindle is your jam, we also have a Kindle version. And so I'd like to offer that to you. You just need to contact the office so that our client service director can send that off to you. Also, as a thank you, a second gift I'd like to offer you is a free family wealth planning session. So if you don't already have a plan, those consults are offered at $750. If you do already have a plan that requires some review by me, typically, those are typically $950. But for going through this webinar with me and taking this journey, I want to offer these sessions to you for free. You will still have to do a little bit of homework. I still need you to do the inventory and assessment, sorry, and a couple of other things, but we will waive the fee for you to come and sit down and paint that picture for you so that you can make the best decisions for your family. So I have a licensing designation called a personal family lawyer. It's a nationwide designation. Sorry. And we distinguish ourselves from other estate planning attorneys in that it's really important for me personally and professionally to have an ongoing relationship with your family, because doing estate planning is not something you should just do once when your children are 2 and 5 and then never do again or never review again. You shouldn't just sit on your bookshelf or in your personal safe, hopefully not on a bookshelf, for 15, 20, 25 years, which I often see. We're going to check in with you every couple of years at the latest and say, has anything changed? Have you had another baby? Have you moved? Have you acquired new property? What's happening in your life? Have you divorced? Has there been a death? Have the people that you nominated in that original plan passed on? Or maybe they've moved away such that they can't be a temporary guardian anymore. Things change. And so these documents need to be reviewed often to make sure that they're addressing your family's needs. Otherwise, why have it? I mean, it's all for naught. And if you've gone through the time, energy, effort, resources to put one in place. It means that you have an intention for it to work. And it is our great desire and pleasure to help you make that happen to the extent we can. If you need to update your existing plan, who are you? If it has been 3 years since you have pulled that thing out of the safe, it's time. If you've had more children, adopted a child, it's time. If you have a special needs child and that has not been addressed in your plan, it's time. If you've divorced, if you have a blended family and you haven't updated, it's time. If anybody who may have stood to receive a distribution in your plan has passed away or you no longer have a relationship with, it's time. There's lots of different times in your life that are pivotal points to pull out that binder, take a look at it, and see if your plan still reflects your needs and those of your family. So you've listened to all of this. Are you ready? You may not be ready in some respects. It's never really a good time to sit down and talk about death and dying, to be quite honest, but I promise to make it the least painful possible. There's always treats in my office, really. There's always treats in my office. And we can talk about it in the most loving and gentle way. We absolutely can. And the sense of relief that washes over these families when it's finally done, when it's signed, when it's finalized, is immeasurable. You just feel a certain kind of relief you didn't even know you needed. So when I go away on a trip, a business trip, a personal trip, I'm even going out on a date, everybody knows their roles. Everybody's got the paperwork they need. My sitter has instructions to what would happen, who she's supposed to call first. It offers a sense of confidence that can't really be compared by anything else. So again, I want to thank you today. If you would like to get your family wealth planning session, your Wear Clean Underwear book, please call the office at 509-624-1610. Ask to speak with our client service director. Please tell them that you have listened to the Kids Protection Planning webinar so we know how to best serve you. Thank you so much.